of serving on the Bill Committee. I'm fortunate also to have been spared some of the polarisation that's affected this bill. So I'm talking today from a position of complete objectivity. Having also tracked this really important journey very carefully for many years, both professionally and personally, I believe this is an essentially good piece of work and that it deserves a fair passage through Parliament. As I stated at second reading, any new legislation needs to be set in context of the prevailing macro conditions and previous legislation. This fills a void where little has previously existed, so I commend the Minister for his vision, resilience and fortitude to date. The bottom line is that this bill does deliver on the Conservative Manifesto commitment to address the issue of vexatious claims, and it makes the first substantial amendments of its kind to the Human Rights Act by limiting the time in which claims can be brought. And I can tell you from experience that this is what our armed forces want. They aspire to be better protected in law. They want to know that their country values their service. They need to know that they'll be supported if they pull the trigger lawfully. And after the misery of the ambulance-chasing years, they want the threshold for prosecution to be raised so that the endless knocks at the door finally stop. This is a no-brainer.
The Honourable Gentleman give way.
Please.
Thank you very much. Thank you very much, Mr Deputy Speaker. I thank my honourable friend for giving way. Not only the ambulance-chasing lawyers, but it's really good that we won't ever see the Iraq historic allegations team who really made our soldiers' lives hell when they investigated them as well. That won't happen again either.
I could not agree more. I'm aware that several amendments were tabled during the committee stage, but none were taken forward. Hence, this bill is essentially unaltered from second reading. Perhaps it's no surprise today that such a large list is being considered, and I will admit that some of the amendments do have merit. Having been contacted over the weekend by the eminent, honourable and gallant members of both Barnsley Central and Halton Price and Howden, I've looked in particular at amendments 1 to 10. My view, however, is that this bill will not prevent the UK from rightly prosecuting acts of torture, war crimes, crimes against humanity or genocide, and that the bill does not need to exclude these from its triple lock because existing provisions already exist in law. I also struggle with the notion that the MOD would somehow fail to investigate or prosecute because the bad apples will always face justice, as indeed they were during my time in uniform. Regarding torture, the government's further position is that the presumption against prosecution will not prevent any prosecutor from considering the severity of the crime or the unique circumstances in which it was committed. Indeed, war is a nasty business, so I do not believe that a court should somehow be prevented from giving weight to the mental health of the individual or the prevailing conditions. Hence, I am minded against Amendments 21 and 22. I agree with the Minister here that this would be nonsensical, as prosecutors should give recognition to the difficulty, the trauma and the acute stress of military operations, as any member of HM Forces will testify. In addition, the bill confirms that on a case-by-case basis, a prosecutor can determine that a crime is exceptional, so there is no collision course here with the UN Convention Against Torture, the Geneva Convention, The Hague, or even NATO, as nothing is going to be swept under the carpet. As for the 5-year time limit, this is correct, as the clock will start ticking from the point at which matters come to light, not from the time of the alleged incident. It was also the overwhelming preference during the public consultation. Not only should it be possible for all of the evidence to be gathered within a 5-year period, I concur with the Minister that memories do fade, that evidence does deteriorate, and that it remains in the interest of everyone involved to deliver justice quickly. I do not therefore support Amendments 18 to 19, which seek to lengthen this period to 10 years. This is ultimately about taking pressure off our people, not prolonging it. Part 2 of the bill relates to claims by service personnel against the MOD, as 94% of all employer liability claims against the MOD since May 2007 have been brought within the limitation long stop of 6 years. I agree that there should here be a time limit too. To be fair, I've considered the suggestion that this bill is more about protecting the MOD than it is about protecting HM Forces, but this too is ridiculous. Noting that the time limit extends here too from the point at which the issue first came to light, There is more than enough time here for any complaint to be submitted, and the MOD cannot simply write a cheque for yesteryear. So I'll be voting against new clauses 5 and 6 and Amendment 23 if they're chosen. Lastly, I'm aware that this bill has attracted lots of interest in the media in recent months, so I want to set the record straight. I'm not convinced that the criticism from RUSI, the Royal British Legion, the Joint Committee of Human Rights or other senior figures is necessarily fair, as the legislation delivers what it says on the tin. Having read it in detail, I am clear too that any new presumption against prosecution is not a statute of limitations, and it does not in any way create a bar to either investigations or prosecution. Mr. Deputy Speaker, unlike some, I have complete faith in both our legal system and our armed forces, so I commend this bill to the House.
Lloyd Russell-Moyle.
Thank you, Mr. Deputy Speaker. Look, we all agree that the